Our next panel is called Silicon Valley Spotlight, Regulation, Enforcement, and Prosecution Trends. It's kind of a unique panel at this conference. Instead of looking at issues through the lens of a specific regulation or enforcement program initiative, this panel views SEC enforcement through the lens of industry, specifically the interesting and complex world of Silicon Valley. So let me start off with introducing Jessica Chan, Senior Director of Government Investigations and Special Matters at Uber. She leads the legal team at Uber that responds to government investigations and inquiries on behalf of the government. She also had over 5 years as an attorney in the SEC's Division of Enforcement. Also, you'll see through the day that we have an incredible roster of in-house people on panels, and I have to give Jessica credit for helping to connect this conference to all these people. It makes the day really interesting and really appreciate it. Thank you, Jessica. So welcome.
Thanks.
Our moderator is Mike Dicke. Always pleased to have Mike with us. He's a partner at Fenwick and chair of the firm's securities enforcement practice. He's also the co-lead of the blockchain practice. He was previously the associate regional director for enforcement in the SEC's San Francisco office. Welcome, Mike.
Hi.
Brett Kumm, senior managing director in FTI's Forensic and Litigation segment. He's based in Portland, Oregon, and he leads dispute consulting and forensic investigatory engagements, mainly related to complex financial and accounting litigation matters. He previously spent 18 years providing advisory and M&A services at KPMG and Anderson. Welcome, Brett.
Thank you.
Next up is the SEC staff member on this panel, Jason Lee, Associate Regional Director in the SEC's San Francisco Regional Office, where he oversees the enforcement efforts for Northern California and the Pacific Northwest. He joined the SEC in 2013 and was a member of the Public Finance Abuse Unit as well. Welcome, Jason.
Happy to be here.
Finally, let me introduce Randy Luskey, partner Paul Weiss in the litigation department here in San Francisco. His practice focuses on white-collar investigation matters, and he previously served as an AUSA in the U.S. Attorney's Office for the Northern District of California. Welcome, Randy.
Morning, everyone.
All right, let me turn over to Mike.
Thanks, Bruce. So our job today is to talk about Silicon Valley issues and also to not try to steal all the issues for all the other panels that you're going to hear from. So you won't hear the word crypto, you won't hear some of the other insider trading and other things for the most part. We tried to come up with some topics that might not be covered in other panels. We'll see how we do. I wanted to start by welcoming Jason, who this is his first time speaking at Securities Forum West as the Associate Regional Director. You've been on other panels, Jason, here at the Forum. What other ones have you been on?
So this will be my fourth panel, I think. So last year I spoke on the Insider Trading 360 panel. So talked about SEC versus Panuwat, shadow trading case, amongst other things. And before that I talked on panels about the pandemic, the COVID pandemic, and the impact on SEC regulation and securities litigation.
So how long have you been as head of enforcement now?
So pretty much 6 months. I started in December of last year, and up till now, that's when I've been in my current role.
So obviously have been at the SEC since 2013, so you worked your way up through the ranks, you know the office well, know the region well, but what do you think is your biggest surprise since taking over?
You know, I wouldn't say there's necessarily any major surprises. It's been a lot of work. It's been very interesting. And I think for me, part of it is, I'm pretty lucky. We have a large group of very experienced, very smart folks that I work with. You know a lot of them, and that's made it easier. So to the extent that there was a surprise, it didn't feel so surprising. So couldn't really think of one particular thing that pops out.
So one challenge you have is a challenge that a lot of us have been going through, and that's the figuring out the transition back to the office, or what the working environment looks like in maybe a hybrid area of work from home office. Where is the SEC Enforcement Division at right now with working from home, being in the office, and how is that affecting your work?
Yeah, so there are a couple of different ways to answer that. One of which is like actual official minimum days in the office, right? So starting from late March, the SEC started with all of its staff sort of a return to office formal process. Prior to that, it was, still officially work from home process or protocol, coming to the office as needed. So as is, staff come in minimally. Most staff come in minimally twice per pay period, so twice every 2 weeks. But that varies, and a lot of people certainly come in more than that. That's just sort of like the minimum, right? To the extent that there's a need to come in, and maybe this is partially where you're going to, whether it's testimony, a proffer, a Wells meeting, anything like that. So just anecdotally, I can speak from my experience in the San Francisco office. I think the number of those meetings in person have gone up pretty substantially since March, even before that, but certainly after the official return to office has gone up. So I would say there's still definitely a hybrid approach, but there's a lot more of the pre-pandemic in person than prior to March.
And is San Francisco pretty much the same as other offices, or does it differ by region?
So there I can't speak, firsthand on everything, but my understanding is that SF's pretty consistent. So it's going to depend on the attorneys involved, the outside counsel. It's going to depend on the witness, where they're located, sort of their role in whatever issue is being looked at, cost issues, logistical issues, and also the particular staff that you're engaged with. So if you're across the table from particular staff, the SEC, maybe not even in San Francisco, they might have a particular preference. But yeah, I think that trend in general seems to be consistent with what I'm hearing.
And are there other matters for testimony where the staff where the defense counsel, for instance, wants to come in for whatever reason, wants to have their witness in? Does that request usually honored? And the converse, if the staff attorney taking testimony wants a witness to come in, but for various reasons, counsel suggests remote testimony, how are those kind of situations being handled?
So again, I think a big turning point is sort of March this year, when officially the SEC was back in the office. I think that to the extent that a witness or an attorney or a team wants to come into the office to present, my experience has been we typically will do that. I think there are a lot of benefits of doing that. There are a lot of benefits remote for sure as well, right? But I think there are a lot of benefits of being in person for all meetings, whether it's a presentation or testimony, certainly. So I think we'll typically accommodate that. Again, there might be particular circumstances with an attorney involved that might impact their participation in person. And the flip side, I think that typically we try to be reasonable and sort of approach situations case by case about if someone wants to come in remote but we prefer to be in person. But that's really going to depend on who that witness is, for example, and is it going to be doc intensive? Are they long offering documents? To the extent we really feel like it needs to be in person, unfortunately, depending on your perspective, we'll insist that it be in person. But to the extent that we can accommodate, we're open to discussing, and I've seen accommodation.
Okay. There's also a new U.S. attorney for the Northern District of California, well-known and respected white-collar litigator and defense lawyer, Izzy Ramsey. Randy, the San Francisco Northern District office has a great group of experienced prosecutors in the white-collar securities fraud unit. Some of them are here today. You know the office well, coming from the office and practicing there. Izzy. What do you expect from new leadership? Do you see them opening more white-collar securities type cases, or doing different type of mix? Or what overall do you expect?
Thanks, Mike. Nice to see everyone. So first of all, that is right. There's a new sheriff in town, Izzy Ramsey, and he happens to be someone that many in this room have worked with over the years, know very well, and respect tremendously. I think there's a sentiment in this district that we're all in very good hands. There's always uneasiness in the business community when there's a transition like this. But I think we've been spoiled in this district for quite some time with really fantastic U.S. attorneys. With respect to priorities and areas of focus for Izzy, first, one thing that's top of mind for him, and this is nothing new, but it's certainly something that I know he is focused on, is that Izzy would like to see this U.S. Attorney's Office continue to be sort of the first line of defense for investigating and prosecuting cases in our district. So cases involving companies, in Silicon Valley, in the Bay Area. There's a sentiment that other districts have sort of been fishing off of the Northern District pier for some time, and we see recent examples of that. The OZ Media case involving a Mountain View company indicted by the Eastern District of New York, or the FTX case involving, Alameda Research primarily, right across the Bay Bridge, indicted by SDNY. And I know it will be an area of focus for Izzy, not just for him, but for the U.S. Attorney's Office as a whole, to get out in front of those cases, to show activity, to integrate with the Silicon Valley and Bay Area law enforcement community, so that this district is the line of first defense when it comes to corporate victims reporting those types of issues. And so I do think we'll see some movement in that direction. With respect to substantive priorities, Izzy has worked on a wide variety of securities cases and trade secrets cases over the years. I don't think it's any secret that those will continue to be a focus. This office, the U.S. Attorney's Office in the Northern District, has always had a very smooth working relationship with the SEC, and I would expect that collaboration to continue unless Jason tells me otherwise. I do think that, and so I don't think we will see sort of a big difference in terms of the quantity and type of securities cases that are being brought. There may be some structural changes to this unit. There's people in the audience here that would know better about that than I would, but Izzy's only been kind of in the saddle for about 60 days now. So those changes may be forthcoming. There's currently a corporate fraud strike force that has undergone some name changes over the years. It used to be the white collar unit and the securities fraud unit. And the idea of that group is to bring really senior experienced federal prosecutors to the forefront and work with speed to bring these types of securities cases or other white collar cases. And remains to be seen whether that group will be renamed or changed, but I don't think we will. I think it will exist in some form or another. And lastly, in terms of priorities, I do think that Izzy and the U.S. Attorney's Office will continue to focus on some of the cases we've seen recently involving private companies, emerging companies who are investigated for alleged misrepresentations to investors, for instance. So the Theranos case and the Frank case and OZ Media and cases like that. There's always been a sentiment that some companies may be running fast and breaking things, and we're starting to see more of those cases investigated and prosecuted criminally and not just looked at by the SEC, and I expect that trend to continue.
So you're predicting more turf fights between Northern District and Southern District, Eastern District?
Not only predicting, but already seeing some in our practice. And so I think that those things are happening and that it will be a priority for this office to win some of those turf battles.
What's a company to do if they get dueling subpoenas from different U.S. attorneys' offices?
Respond to both of them.
No, wrong answer.
Yeah, unfortunately, oftentimes it is the company that is caught in those crosshairs, but it is not typically it does not typically change your response strategy. You really do need to respond to both subpoenas typically.
Okay. Jessica, as somebody who at a company that could theoretically get such a process every once in a while, you lead the investigations team at a high-profile Silicon Valley company. New leadership changing at the SEC in town and the U.S. Attorney's Office in town. Does that change your approach to your internal investigations or your work approach at all?
Thanks, Mike, for calling our company out. And that seems like a pretty loaded question, but I don't think it's going to come to anyone's surprise that I don't think that the change in leadership at either office would materially affect my or my team's job. As you all know, Uber's had its fair share of ups and downs. That might be an understatement. We've probably had more than our fair share of ups and downs, but in 2017, I really think that we embarked on a pretty remarkable transformation for the company with the new management team, with a renewed focus on its commitment to compliance. So one of our company's core cultural values is do the right thing, period. This isn't just a talking point, but it is really a core tenet. that Uber employees live by every day. And what that means is not just meeting minimum legal requirements, but also going above and beyond and really doing right for all of the users of the Uber platform. And another way that the company has really made sure to make sure that this value is firmly rooted in the company's culture is really hiring a lot of former government attorneys. So Tony West and Scott Schools, as you all know, former senior DOJ officials, are Uber's chief legal officer and chief ethics and compliance officer, respectively. We've got former government attorneys sprinkled out throughout the chief legal officer organization, including all members of my team. And I think this is a really important point because, the hiring of former government attorneys, these are the people who, really understand the government's mission, really agree with the purpose of the applicable laws, and they're working with the company every day to make sure that the company does the right thing. So it's kind of a long way of saying I don't think that things are going to change with the change in leadership, because I think the company has really already made that transformation. But I do see this as a good opportunity for the company to continue building its relationships with both offices based on engagement and trust, and so I'm really looking forward to that.
Good. Brett, what's your take on the new change in leadership?
A lot of us thanks, Mike. A lot of us in the forensic community have worked with Izzy over the years, and particularly a number of us at FTI. And so people are excited that he knows the process. He knows what forensic accountants, the role that they can play, what they can and can't get into, and where they can assist on these matters. So our industry is excited to have him in this role. The one thing I might leverage back to is a comment Jason made about the SEC and the DOJ in terms of meeting in person. I'd like to thank the SEC and the DOJ just for this last year on some complex investigations. The boards, I think, find it very refreshing that the SEC and DOJ are willing to meet in person when it's a complex investigation, and you've gone through the investigation with the board, you've flipped files with them, you've showed them the emails, you've given them the context of what the issues are. I think the boards get nervous when you say, well, is this same readout proffer going to be done to the SEC? And you mentioned to the board, well, we're not sure yet. We're trying to make an in-person meeting with the SEC, but we've been successful and appreciate when we request an in-person meeting to have that available. So thank you.
Yep, we love presentations, so by all means.
Before going to the next topic, I want to circle back to Jason and give you an opportunity, now we get to more substance, give you an opportunity to do your disclaimer.
Yeah, no, thanks. I actually put my little note here. I was mostly talking about my own experience. I appreciate it. So, the views I expressed today are made in my official capacity as an Associate Regional Director for Enforcement at the SEC, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the SEC staff. Thank you, Mike.
It won't be long till you have that memorized. You don't have to look down.
I don't know if you noticed, it actually slightly changed. We got a slightly different template.
I missed that.
That's right. That's why it's in the notes.
Yeah, let's talk about different topic, cooperation, which is near and dear to a lot of companies and registrants in Silicon Valley. And there's been a lot of movement and new things in the last year. Jessica, the SEC's year-end report specifically called out a number of meaningful benefits that companies received or individuals received from cooperation. You want to talk about some of those message cases?
Yeah, sure. So, DOJ has implemented specific cooperation programs such as, the Antitrust Division's leniency program and, of course, the Criminal Division's corporate enforcement policy, but I still don't think that we have a very good idea of what benefits cooperation can bring with respect to the SEC. So I was pretty interested to see that the SEC's year-end report for fiscal year 2022 actually calls out recent cases that the Commission believed exemplified cooperation. But I have to say, after looking at these cases, it's pretty hard to sort of tease out among the cases cited in the release a pattern. In all of the cases, cooperation still meant the filing of charges against the company, and in 2 of the cases, it's true that SEC didn't impose civil penalties. The first headspin involved the conduct of a significant fraud, which led the company to replace its management and expand its board, among other things. The second, Pro Petro Holding Corp., was a Perks case, and the cooperation cited involved hiring an entirely new management team with significant public company experience, hiring additional finance department personnel, installing several new directors, and developing new controls, policies, and procedures concerning Perks. These were the two that involved no civil penalties. In the last case, involving Baxter International, which was a fraud and books and records case involving foreign exchange accounting, the company was charged and still had to pay an $18 million civil penalty, despite self-reporting and substantial cooperation provided in the case. So the number of cases here is small. There are only 3. So maybe there isn't much to be gleaned here, but the message does seem to be that even if a company does everything that it can, remediate, completely change its management team and board, it may still have a shot at receiving no penalties, but will still be charged. And anything less, and it's still likely that the commission will levy some pretty hefty penalties. The presupposing of a charge in these cases with strong remediation is a little bit puzzling to me because, as those of us in-house know, mistakes can still happen. There are rogue employees, even at well-intentioned companies with pretty strong compliance programs. So, if a company has self-identified an issue and quickly remediated, charging the company would not appear to serve that much in the way of specific or general deterrence. But this isn't to say that, obviously, reduced or no civil penalties isn't meaningful. It is. One thing I did learn upon going in-house, though, is that a charge by the SEC stays with the company forever, right? And it can have pretty detrimental effects and great collateral consequences. It damages the company's reputation. It can also detrimentally affect a company's key business and government contracts. And so these can be equally, if not more, damaging than the levying of penalties. But I know Jason has something to say about this because we've been talking about it for a bit. So eager to hear what he has to say.
Yeah, I know. I mean, everyone, look, you raise fair points, and I definitely understand your perspective, and you have the unique perspective sort of being on both sides. Well, not unique, but many of us here, but you do from the SEC as well. I guess I just note a couple of things. So, hopefully in the coming months and as time goes on, more of these settled OIPs or settled orders are going to come out. More releases explaining settlements and district court actions will come out that provide more guidance or more explanation on some of the thinking in terms of what specific conduct or cooperation or remediation impacted or had a role in the commission's ultimate decision to give credit, right? So just to address one of your points is that, 3 OIPs or 3 settlements discussed in the fiscal year 22 year-end report. I think that you'll see more coming out, and I think that hopefully that'll give folks a better sense of the type of specific cooperation we have in mind. You're right that often the remedies are no penalty or significantly reduced, but at the same time, as we all know, the penalties can often be as high as the tens of millions, if not in the hundreds of millions, right? And so it's not a small thing to have a reduced penalty or no penalty, even if there still are the permanent injunctions or cease and desist orders. I can't say sort of in the future if there's particularly strong cooperation or other factors come into play, whether there'll be even additional credit that's offered. It's always going to be case specific or fact specific. And the reality is that I appreciate that different entities and issuers would like to cooperate in many instances. And the reality is that sort of the degree of cooperation, the degree of remedial measures, both the speed they're implemented, the actual effectiveness of them, the speed of self-reporting, there are degrees and differences. Similarly, pre-existing self-policing mechanisms and controls come into play, the egregiousness of the conduct. Is it just one rogue employee, or maybe it's a broader issue? How big of a market impact is in there? There's a lot of factors. There's nothing one specific thing that's dispositive. So that's going to feed into the ultimate result. And, I guess with a small sample size, maybe it's harder to gauge some of the benefits potentially, but hopefully with a broader sample size, you'll see more. And the only other thing I'll add, I don't want to take up too much time, is that there is another OIP, a settled SEC order that came out in October 2022. So within the next fiscal year, like this fiscal year, so it wouldn't have been included in the prior report. You guys, if people are curious, you can check it out. It's called Kronos Group Inc. And I felt like there were some specific things in there that were helpful, maybe even a little more detail that were in some of the other items you mentioned. And real quickly, two of them I'll mention is in Kronos, the company conducted an internal investigation. First of all, they had self-policing procedures in place that then led to them identifying an issue that led to them doing an internal investigation and then self-reporting. That was a factor cited in the order. Secondly, before the investigation was even done, they reached out to the SEC and self-reported. So not waiting for a full result. I mean, everyone has to make their own decision and call, right? But we appreciated sort of the quick action. And then the last thing I'll flag, there's more in the order, but the last thing I'll flag is that, I'll be careful how I phrase this, but there were facts shared from the investigation in terms of providing it to the SEC staff, right? So not work product or anything, but facts that were learned that were important that gave assistance to the staff that staff may have eventually uncovered on their own, but helped expedite the process.
Two practice pointers for outside counsel, I think from the cases, and I was involved in one of those cases mentioned and can speak to these. One is you want to be specific when you come into the SEC and talking about what remedial actions you've taken. I mean, you want to make sure you've got from the client, you've got the laundry list of everything that's been done, because those things do matter. The SEC does listen. Some of the specifics will show up in the order. And two, know the collateral consequences to your client's business of accepting any particular charge that you're negotiating, and explain where there are real negative consequences to the business. Explain to the SEC what those negative consequences are, and make your best pitch to try to find a solution that doesn't, that maybe involves a different charge that doesn't have those types of collateral consequences. If you're in a cooperation mode and the staff is appreciating your cooperation, you'll obviously get a lot more of an audience and a lot more willingness to work with you at the point of resolution. I wanted to also talk about, Jessica, you mentioned the DOJ's corporate enforcement policy and cooperation policy. Randy, there have been changes recently to the DOJ policy. You want to highlight those?
Yeah, absolutely. And before, I think many of us are familiar with the Monaco memo and sort of changes to the enforcement policies or cooperation policies. But I wanted to pick up on one point that Jason made about the Kronos order, and one of the considerations that order really highlighted, which was the speed of self-reporting and coming to the commission before the company had completed its internal investigation. Because I think that really gets at one of the key changes in the Monaco remarks and memo as well, which is that it's not just enough for companies to investigate alleged misconduct and then complete the investigation and eventually report to us. We want you to act with speed, swiftness, without delay. And in fact, both the Kronos order and the Monaco's memo suggests that companies should consider doing that before an internal investigation has been completed. That is really difficult. And I understand the government's perspective on this. You don't want to lose evidence. You want to make sure that you've got fresh witness recollections, all of that sort of thing. But the idea, internal investigations take time. There are administrative challenges, logistical complications. Just getting the documents collected and the e-discovery platform set up can take 30 to 60 days. And so the notion that companies, in order to receive full cooperation credit, or the Monaco memo could even be read to suggest any cooperation credit, companies need to make a decision to sort of walk the matter in with evidence of individual misconduct before the company and its lawyers have had a chance to review all the documents, interview the key witnesses, make some factual findings. It's tough. It's a tough pill to swallow. And so I think that there's going to need to be balance. There's going to be those cases where right off the bat, we've got a problem here. We discovered this text message. There's no question that this creates an SEC reporting issue or a trade secret misappropriation issue, whatever it is. we should self-report and do so immediately and then work collaboratively with the government to sort of investigate while they are also investigating. There are other cases where you just don't know what you have in the first 30 days or 60 days. There are those cases where you have people coming forward suggesting wrongdoing. Maybe there's a document that seems to corroborate that, but you have to talk to witnesses and you have to review the ESI before you know whether you really have anything to report. And so I think that's going to be one of the challenges in navigating the DOJ's new cooperation guidance. And we'll talk about some of the other aspects of that guidance and changes to that guidance in a moment, including really highlighting the need for companies to have robust policies around third-party ephemeral messaging apps and bring your own device sort of text message issues.
Well, let's go right to that, because I do think it's an important part of the policy. It's gotten a lot of attention. Let's start with what's in the specifics in the policy that's come out on ephemeral messaging.
Yeah, so in terms of the specifics, the Monaco memo lays out a number of key points, which I'll mention, but then also there have been remarks by the Assistant Attorney General at the ABA White Collar Conference that kind of take it a step further. And the general takeaway is, first, companies need to ensure that they have policies that either prohibit the use of ephemeral messaging apps and sort of bring your own device text messaging services that the company doesn't have access to, prohibit the use of those texts for business-related communications, or if you allow your employees and your workforce to use those methods of communication, you better make sure that you have access to that data when we come knocking. When there's a subpoena or a CID that asks for texts and all messaging apps and all chat messages, we don't want to hear, sorry, we have no way of gathering that data. And that creates some real challenges because a lot of companies, especially here in the Valley, have gone to bring your own device sort of systems where you don't have back-end access to the Apple iCloud text messages or WeChat. And you can have every policy in the world that says, hey, workforce, you're not allowed to load those apps on your phone, and you're not allowed to use them for business-related communications, but we all know it's happening. And the government believes that's where the best and juiciest evidence is, and they're probably right. And so it's a tricky issue, but that's the current lay of the land in terms of the guidance. That's
nice that the DOJ says all that, and that's what they want. But as you said, it's a practical matter. It's hard for companies and registrants to enforce that. But so what's the enforcement mechanism within the policy, or where does the rubber meet the road?
I think the rubber meets the road with the Assistant Attorney General's comments, where he essentially said, we will ask you about your BYOD program and associated policies. If you have not produced those communications from third-party messaging applications, our prosecutors will not accept that at face value. A company's answers or lack of answers may very well affect the offer it receives to resolve criminal liability.
Okay, there you go. Let's broaden the lens just a bit to this general topic, not just the DOJ policy, but I think it's an important topic for Silicon Valley. I think it's use of ephemeral messaging apps and text messaging and BYO device. Sorry, I'm already thinking about cocktail hour. It's not cocktail hour yet.
Different type of party, Mike.
And this is water, I promise. But it's a real practical problem that a lot of us in our practice are facing. And I think it's more prevalent in Silicon Valley and tech companies where your workers are using these apps more than other industries and other parts of the country. So let's talk about practical guidance. Brett, what are your thoughts on conducting investigations in the world where employees and other witnesses have evidence on their phones or otherwise using these ephemeral messaging platforms?
I think most of us in the room, just looking at the demographics, we're used to the period where we all went and got emails and we got text messages. And then there was this science project, I used to call it, layered on top of that to go into the SEC and explain why the collection was complete, why it was accurate, why we weren't missing anything. What's really changed now, this dynamic, is I refer to them messaging apps, because some of the names that people have been referring these to imply that the data is gone. Often with all the different technologies, depending on how you set up the app at the beginning, a lot of this stuff is just like emails. It's all there. And in fact, we're running into situations where even more data is there than the email. One that we've encountered recently is Teams, which is commonly used. There's a switch within Teams where when someone's drafting a Teams message, that it actually tracks the message and saves it every 6 to 10 seconds periodically. And so we've had circumstances where we've presented to the SEC and the DOJ where it's the message on its surface, the last message that was sent, provided certain context for a matter, but then when you looked at the stream of thought, consciousness that the person had in drafting the message, there was actually a different outcome to everyone's conclusion of what was going on. So with that said, in all the different applications, in all the different types of applications that are being used, you really have to come at it as a risk-based approach. And so the way a typical proffer that we're giving the SEC, the way we come at it is to go over with the staff at the beginning what's been collected, why we think it's a good collection, get into the substance of the investigation, read out through the proffer, then loop around at the end of the presentation and go back through the process of the collection of the data to explain why we think that was a good collection, because you can't really represent anymore that you collected everything and it's complete and accurate and put the scientific process on top of it, as I used to call it, to say that it's complete and accurate. It's got to be risk-based.
Jessica, how are use of these new technologies impacting your practice?
Yeah, I mean, it's tough, right? Because a lot of companies, as Randy and Mike noted, have now implemented BYOD policies. It's not only cost effective for companies, but it's also what a lot of employees prefer. So you really have to deal with this pretty critical issue. And then on top of that, now that we're in this post-pandemic world where sort of lines between personal and work have blurred, it's even more critical to sit down and sort of understand where the company stands with respect to personal devices. Obviously it creates a ton of headaches when communications are needed to be collected and preserved. A lot of the times whole devices have to be imaged, and that means, your personal photos, your music, your personal communications, all of that is going to be imaged as well, and that just creates a ton of stress for in-house counsel and for employees alike. So what do you do? I mean, there are some sort of practical tips, right? Obviously companies should only approve of messaging systems that have enterprise versions. And that means that they're meant to be deployed by a company. This ensures that the company has the ability on the back end, as Randy said, to preserve messages on that system. Companies should also be very clear to employees as to what is considered an approved method of communication and what is not. They should also be clear with employees about the need to separate work and personal communications. Even providing tips on how to organize communications. As all of you know, many times your work colleagues are also your personal friends, and there's a particular danger when communicating with each other using personal devices. Also, when responding to a government investigation, it's always important to conduct custodial interviews to understand how employees who may be witnesses to a matter communicate, and then gather their devices as necessary. And then finally, which is, I think, in the policy itself, enforcement is really important. So it's important for companies to ensure to enforce their communications policy. And if they become aware of employees who are using unapproved methods of communications, companies need to make sure that they're appropriately disciplined.
Okay. We're getting a little short on time. I want to talk about something that's definitely top of mind for the region. That's the recent bank failures. Silicon Valley Bank, First Republic Bank. both regional banks here in the Bay Area, as well as a failure of Signature Bank, which isn't here, but had a lot of exposure to tech and crypto. I knew I had to mention the word crypto once. Jason, there's been reports that the SEC is investigating Silicon Valley Bank and First Republic, looking at trading by executives ahead of the bank failures, which does make a lot of sense that would be an angle for the SEC. But I'm wondering, not speaking specifically about those banks, but in general, when you have a bank failure in a particular region, is there a role for the SEC alongside the banking regulators in investigating what happened, what went wrong, what are the potential theories where the SEC could get involved?
Yeah, so I'm probably going to give you a super general answer, so just as a general matter, I think that whenever there are significant market-moving events that impact the price of a particular issue or securities or a particular segment of the securities market, anytime there's significant market volatility, the SEC staff is going to take all necessary steps to identify and investigate any potential securities laws violations, all the angles and any potential misconduct. I know it's a very general answer. So just putting that out there generally, we're always looking and paying attention when things like that happen. It doesn't always mean it's a securities law violation, but there could be. And so our job is to look and make sure that we've done a close look. And I think that applies to issuers or market participants from a variety of industries, right? So there might be some regulated by different types of government agencies, but it doesn't mean there can't be overlap in general, right, in any matter with the SEC. If we're talking about disclosure, if we're talking about insider trading, insider trading by nature is based on trading on MNPI, right, material non-public information. That information could be stuff that should have been disclosed that wasn't, right, just in general. So, that's how I'll answer your question generally.
Yeah, no, that's interesting and helpful. Brett, are you seeing an uptick in investigations involving banks in this region, or do you expect an uptick?
Yeah, we are seeing an uptick. We've had some involvement, as many of you know, in some of the larger banking issues in the past, and then we're seeing an uptick with the current matters. I personally have been engaged in one of the matters, so I'm kind of limited what I can say at this point, but definitely seeing an uptick with the regional bank issue.
Okay, so I struck out on getting specifics from the first two people. I don't know, Randy, what about the U.S. Attorney's Office and their role when you have a regional bank failure like we've seen, and this particular U.S. Attorney's Office, I think, has expertise in bank cases and brought some important bank cases in the past?
Thankfully, we haven't had a ton of regional bank failures in our district, and so I'm hoping there won't be a lot of activity in that area. But no, the office has been focused on financial institution cases, including the Wells Fargo issues over the last 5 to 7 years, and I think I can't comment on where things stand with respect to these current investigations involving SVB and others, but I'm sure the office is looking at it in conjunction with the SEC.
Okay, so 3 strikeouts.
Exactly.
So last topic. Every regional office has a particular type of case, I think, that they like to be known for. I almost look at a certain branding for the SEC regional offices. One area for sure, I think that the San Francisco office has made its reputation on and been very important in the last few years are private company cases. Cases involving especially large late-stage private companies and potential misconduct, investigations involving potential misconduct, some high-profile ones. There was a recent article in the New York Times titled "The End of Faking It in Silicon Valley." So are we at the end? Where are we with that? And Jason, you want to comment on some of the cases that were mentioned in that article, or in general on your office?
Yeah, I'll just do it real fast. So yeah, certainly given our region here near the Valley, the SEC San Francisco Regional Office has a lot of experience working with early stage and definitely late stage private companies like startups brought a lot of actions in the past, looked at a lot of companies, didn't bring actions. The New York Times article is an interesting one if you haven't seen it. It talks about a lot of publicly filed actions, amongst other things, both criminal and civil. I would just say that, there's a few local entities here, or at least entities with headquarters here that might have multiple offices. A couple were mentioned earlier. So there's Aussie Media, which is headquartered in Mountain View. There was Headspin in Palo Alto. Another interesting one you might want to take a look at is Frank. They're actually based out of New York, but similar idea, a startup. And rather than getting into details, I don't think we have a ton of time. I'll just say one theme I saw, you can draw themes across everything, is that false statements related to revenues or number of customers, so extremely exaggerated customer base, whether it's posting logos on a website that maybe suggests you work with those companies, or in the case of the Aussie Media case, pretending to be an executive at another company to say that that company, Aussie, does business with you. So, interesting stuff.
All right, there's lots more to talk about. BYOB this afternoon, and we'll gather outside and continue the discussion.